Good morning to all of you. We are today going to discuss the case law on anticipatory bails and also whether the High Court can ask the investigating agency to arrest the accused or not. Please remember, according to section 41 crpc, a police officer has to decide whether to arrest or not. That's why a police officer may, without warrant from a magistrate, he can arrest like that. In section 41 CRPC clearly tells you. Once again, it is reiterated by the judgment given by two judges bench in the Supreme Court. While disposing the SLP number 4123 by 2021, in the case of vishwanath Birdar is a sub-inspector of police versus Deepika and others. Yesterday, that is on 16/6/2021, two judges bench of Hemant Gupta and Ram Subramaniam held that it is for the investigative agency to take a call as to whether to arrest the accused or not, and the court cannot direct the police to arrest the accused. Main point is this one. So let us know as to what happened, what transpired, how this judgment has to come like that. Let us discuss. All this, the genesis goes to say it happened in Mangalore area of Karnataka state. The accused was a police officer, sub-inspector. The complainant, of course, name should not be disclosed. The complainant, she was a lady. So under the false promise of marrying her, he had committed the aggravated sexual assault, and basing on her complaint, a case under section 376 and 376 IPC and also 323 IPC was registered against him. Good. So he has applied for anticipatory bail before the 6th ADJ Mangalore, and the Honorable Court was pleased to grant him anticipatory bail. But when the victim, that is the complainant in the case, when she approached the High Court was pleased to dismiss the anticipatory bail granted by the ADJ. And the High Court has come to the conclusion, it is clearly held that it is a classic example where the police tried to support the accused in such a heinous case of rape. Therefore, the anticipatory bail granted him is cancelled. And the investigation was also handed over to the COD, Corps of Detectives. Normally in AP we call it as a CID, Criminal Investigation Department. So investigation was handed over to COD, and the High Court ordered that the investigation should be completed within 4 months. The High Court has also ordered that action should be taken against the erring police officers who have supported the accused person to flee away from the clutches of the police. So since he was not arrested, and definitely since he was a police officer, maybe under the impression that these people were hand in glove with him also. Court has taken it very seriously. So it's all okay. But the main point, now, the last sentence the High Court has ordered is that the investigation officer is directed to arrest the accused and produce him before the jurisdictional court. So this was raised objection. Now this Vishwanath, he has approached the Supreme Court and filed an SLP. So he is not an ordinary man. He has gone to the Supreme Court. Anyway, the High Court has given the orders on 25th April 2021. So the Supreme Court has given the orders on 16th June 2021. So early, he was lucky enough. Normally we have been seeing the bail petitions have been pending in the Supreme Court and High Courts for months together. Luckily, he has got enough justice. Right. So now here the complainant told the High Court, Your Honor, I am getting a number of life-threatening calls. If he comes out on bail, definitely there is no protection to my life. Same thing she is repeated in the Supreme Court also. She has appeared in person in Supreme Court, she stated same thing. Then Justice Hemant Gupta stated that, madam, you have got another remedy, alternative remedy. What is that remedy? You can approach the police or the court under victim protection scheme, victim protection program. Of course, that act has not come in so far, but that program is there. So, or you can oppose his bail, you can oppose it just like you came to the Supreme Court, you can oppose his bail also, you can do like that. So, anyway, so Supreme Court reiterated that it is for the investigating agency to decide whether to arrest or not arrest. It is depending on the investigation of a particular crime. So when to arrest and when not to arrest also cannot be told by the court. It is for the investigating agency to decide. So ultimately, no doubt, so many things have come in this case also, because the petitioner's client advocate, he stated that the woman has got a bad history. She has given 3 complaints against 3 persons under section 376 IPC, but still the court said, even though she is a bad character, you cannot brand her as having a bad history, right? So that is most important, because woman of any, whether she is a virtue or not virtuous, we are not bothered. When she has given a complaint, she is the complainant, she will be taken as the victim, and basing on the merits of the case, we will decide the matter, that's all, whether to arrest or not arrest. So definitely they stated that it is not in the hands of the court, only the police have to decide. So now they have come to the conclusion that it is for the police. So Supreme Court has agreed with the High Court in all the parts except the part that the accuser should be arrested by the police. So it is for the investigating agency to arrest or not. This is a very good judgment. Definitely it will be helpful to you. Please read the judgment and enrich your legal knowledge. Thank you.